Ms. Winnis be excused?
Yes, sir.
Okay, thank you. Free to go. Okay, State?
Judge, at this time, the state would rest.
Okay, very good. Members of the jury, the state is now rested, so I need to discuss some matters with the attorneys outside of your presence. So we'll take a relatively quick break, and then we shall return, okay?
All rise. Jury adopted.
Okay, very good. Everyone have a seat. Motions?
Before we start, I'm going to renew my motion for mistrial on behalf of Davion.
I understand. I've taken it under advisement. We'll be discussing it at some point, more in depth, once you guys have had a chance to do some research. Okay, Mr. Gonzalez?
Judge, one thing, I'm sorry, I should have renewed my objections prior to Detective Griffin taking the stand with regard to my prior motions in limine and prior motions as it relates to gang historical violence. So I just want to make sure the record's clear.
Yes, and your motion,
Judge,
your objections are preserved for the record.
Judge, Rashad Murphy would assert that the state's evidence in a light most favorable to them has not set forth a prima facie case to allow the jury to consider the charge of first-degree premeditated murder in count 1 and attempted premeditated murder in counts 3, 4, and 5. As it relates to those counts, Judge, the state's failed to produce sufficient evidence that Rashad Murphy was present at the time of the murder of Charles Jones and the attempted murders of Gino Norris, Xavier Edwards, and Camilla Bentley. There's no video evidence. There's no witness testimony to support his presence at the time of the murder, and the evidence may support he was in Tampa in the hours after the murder, but at 4:40 in the morning on the 23rd of June. I don't believe there's a prima facie case. The evidence presented by the state relies heavily on circumstantial evidence that doesn't rise to the standard necessary to send this case to the jury on a first-degree murder deliberation. The law is that it's not, at this stage of the game, a question at this juncture who the jury believes. It's the legal sufficiency of the evidence of premeditation and Rashad Murphy's part in that premeditation to send the case to the jury on the first-degree murder and attempted murder. This argument kind of dovetails into count 2, which is the conspiracy count, and I'd submit to the court that there's insufficient prima facie evidence that Rashad Murphy intended that a first-degree murder be committed by agreeing or conspiring or combining and confederating with any of these co-defendants in an effort to intend that a first-degree premeditated murder take place. I would submit to the court that the evidence prima facie of conspiracy in the record could be that Rashad Murphy allowed an Airbnb to be used, to be booked on his account, and that other defendants stayed there prior to and after the murder. There's no evidence that Mr. Murphy knew that the Airbnb was in Tampa, that he actually booked it himself as opposed to allowing someone else to book it for him. He did not pay for the Airbnb, and additionally, there's no evidence that he resided there. When viewing the evidence in a light most favorable to the state as it relates to the conspiracy, and all the counts for that matter in the indictment, a rational trier of fact could not find that the essential elements necessary have been proven beyond and to the exclusion of a reasonable doubt, including the lack of any forensic proof as it relates directly to Mr. Murphy, Rashad Murphy, identification of Mr. Murphy at the scene of the murder, participating in the murder, and the attempt on the other 3 victims.
Okay, very good. Mr. Sonardi, any motions?
Yes, Your Honor, we would obviously file a motion for judgment of acquittal and basically follow up with Mr. Gonzalez as it applies to Davion Murphy. There is no physical evidence whatsoever that identifies Davion Murphy as one of the perpetrators of the attempted murders and murders. I think the state's evidence viewed in the light most favorable to the state is that Mr. Murphy, Davion Murphy, came down here. There were license plate readers. He was identified at the McDonald's prior to the homicide. He's identified leaving the Airbnb the next day. There is no evidence whatsoever that places Davion Murphy either in the Black Impala or at the Home 2 Suites at the time of the homicide. Again, the evidence taken to the light most favorable to the state only shows that Davion Murphy was present, and that there is no evidence whatsoever of any agreement between Davion Murphy and any of the other co-defendants to conspire to shoot Charles Jones or anyone else. There's no evidence whatsoever of that other than Mr. Davion Murphy's presence. And we have not denied that he was here. We have not denied that he came here in a vehicle and he left in a vehicle, but there is no physical evidence whatsoever that connects Davion Murphy to any of the weapons that were used, to the vehicle that was either of the vehicles, or that he was even present in the vehicle at the time that the attempted homicides occurred. Taking the light even the most favorable for the state, we would submit that a judgment of acquittal is proper at this time.
Okay, very good. Mr. Wise?
Yes, sir. We also would move for a judgment of acquittal as to all counts. As to the murder and attempted murder charges, and really the conspiracy, there's no evidence of identity as to Sean Gathright. I think that any evidence of identity is wholly circumstantial. I recognize that standard has changed quite a bit in the last couple of years. But the evidence is proven, the light most favorable to the state. He comes to Tampa, he's in contact with co-defendants. Everything to suggest he is one of those shooters, and apparently is shooter number 2, is entirely speculative. Phone records, as we've seen, are not reliable to place him in any exact spot during any of this time period. The ballistics, which, looking from the outside, I think probably when it was investigated, thought there were going to be matches that linked up these firearms found in the house to the shooting. There were not. The casings that we saw can only be linked to having been fired from the same firearm that's used in the shooting, which incidentally is not the one that Mr. Gathright is alleged to have carried in any event. But no matter what, as the examiner said, all she can say is those 2 casings from the house were fired from the same gun. Could have been 5 years apart. Based on all of that, Your Honor, it suggests there's insufficient evidence to prove identity, which would apply really to the attempted murder and the murder and all of the attempted murder counts. As to the attempted murder counts, they're charged as attempted first degree murder. And I don't believe there's been any evidence of any intent to commit an attempted murder of any of these people. Even in looking at this in the light most favorable to the state, and notwithstanding my identity argument, even hypothetically, if there was intent to commit a murder of Charles Jones, there's no intent, even no evidence of any intent to commit an attempted murder of anyone else. And case law specific transfer of intent doesn't apply to attempted first degree murder. So I would suggest in that regard, at best, on those counts, at best, it could be an attempted second degree murder. But even then, I think obviously identity is an issue. On the conspiracy charge, similarly, there's been no evidence to commit a finding that Mr. Gathright did anything to agree, conspired.
I'm sorry, I'm having trouble
Oh, I'm sorry, I was looking down. There's been no evidence that Mr. Gathright did anything to agree. There was no meeting of the minds, basically, evidence to suggest that he conspired with anyone to commit the first degree murder. Now, Mr. Gathright alone has the tampering charge. This one is a very different one. There are 2 elements the state has proved, looking at the statute. One is that something was altered, destroyed, concealed, and removed with the purpose to impair its availability in a proceeding. And number 2, that Mr. Gathright had knowledge that a criminal trial proceeding, investigation, or prosecution was pending or was about to be instituted. Neither of those elements were proven in any way here. Number 1, frankly, I'm not sure what was allegedly tampered. We know that Mr. Gathright goes to his grandmother's house in Auburndale. I'm guessing the state is alleging that's where some tampering occurred. There's been no evidence of what is in the bags that are transferred. Grandma is watching this entire thing take place as the bag is being transferred. There's been nothing, none of the firearms really that were used in the homicide, I would suggest, were ever recovered. But there's no indication.
I'm sorry, you keep lowering your voice. Thank you.
There's nothing beyond pure speculation to suggest any of the firearms used in the offense or anything used in the offense was in any of those bags that were transferred. And even then, there's no evidence of what happens to anything that's in those bags after they're transferred between the cars. To the extent, I don't know if the tampering is allegedly the car being wiped down.
What about all the stuff that was in the sink at his home?
Well, none of that is connected back to anything that was used in the homicide. There's a Glock chassis, which is basically what's used to turn a handgun into a rifle. That's not alleged to have been used. There's a drum magazine. There's clearly no drum magazine on any of the guns. There's a red dot sight. I don't believe there's been any evidence that a red dot sight was used in the firearms.
Were those in the sink soaking in water?
Those are yes. I forget who actually testified to it, but all those pieces are taken out. They're not; those things are not in the sink. It's the cardboard that would have seemingly encompassed those things. But whoever testified, and I can't recall who it was about that, but they pulled the cardboard pieces out and were able to determine what was what, and they testified to, there's KPOS on this box, and that corresponds to I think that's the Glock chassis. And a lot of those items are actually in the safe, like the drum magazine, and we know the scope caps are right there by the sink. So I don't believe that anything that would have corresponded to the cardboard in the sink was shown to have been used in the homicide. So to the extent that would have been the altering, I don't think there's any connection to suggest that whatever's in the sink had anything to do.
Judge, we didn't allege that date. We just alleged on the 23rd for the wiping of the car and hiding of the vehicle.
Okay. So and that was when I was starting to talk about the wiping of the cars. We saw, and as even I believe as Detective Albert has testified, the car is just being wiped down right there, basically on the interior handles, which is basically where if someone is smoking in the car, that's where you expect ashes to go. There's no wiping down further, anything deeper into the car. It's consistent with someone giving the car to their grandmother who wants to clean it out, cursory cleaning. And to the extent there's a suggestion that, something's being wiped off, the rag that was used is actually in the garage and was collected by law enforcement. So if there was any suggestion there's DNA or some kind of I think we heard inconsistent testimony about whether GNR is still tested for, but whatever may have been wiped down, that rag was still in the garage and law enforcement collected it. So there's nothing to suggest that anything was actually tampered with. And then in addition to that, and I just cite briefly to two cases, EI versus State, which is 25 Southern 3rd, 625, and Costanzo v. State, 152 Southern 3rd, 737. And those speak to the second element, which is that the defendant had to know that there was an investigation pending or some kind of proceeding pending or was about to be. And there's no indication that there was. I mean, I know the state speculates to that, but it's got to be more than mere speculation. So this is happening allegedly a few hours after these alleged crimes are taking place. There's no indication that there's any knowledge on the part of Mr. Gathright and Auburndale that there's some kind of investigation that's pending or taking place.
Okay, thank you. Mr. Petridis?
I don't want to interrupt, but I'm going to adopt Mr. Wise's position as to the attempted first-degree murder. I also concur that there is no evidence whatsoever that it was premeditated as the attempt as to the occupants of the vehicle other than Charles Jones. So we would join into that vote.
Very good. Thank you. All right, may I proceed?
Thank you. I'll come up here so don't get yelled at by the court reporter. The state's case relies on a number of facts, social media postings from Mr. Chance prior to and after the murder that require speculation from the jury that can't be exactly said what they mean. His Cash App, which we don't know the meaning behind that. A rental of an Airbnb, which was rented by Rashad Murphy. Alicia Andrews was involved. And the fact that he brought and put in bags into the car with Sean Gathright, all which require speculation, and we would argue the pyramiding or stacked inferences of knowledge of the specific intent to kill Charles Jones, which the state has not been able to prove belonged to Mr. Chance. There's no evidence that Mr. Chance knew what was in the bags he loaded into. There's no evidence what was in the bags that was loaded into Mr. Gathright's car. The video footage from the two venues shows only one time that Mr. Chance can be shown actually driving, and only possibly one time he can be shown with Miss Andrews' phone. The other times the cruise was driving or the phone was used, it's unknown who was using it. Mizzle and Charles Jones were providing live real-time updates of where they were, and there was text messages from Akila Enright to the Fat Boy indicating that they were going to Beezer's, which I assume would be Teasers. The travel patterns of the cruise at the Home 2 Suites is not enough to indicate Mr. Chance's knowledge of the intent to kill Mr. Jones that night. And what happened after the murder, again, relies speculation on social media posts that have the possibility of many meanings, and I would argue that doesn't rise to the level of proven knowledge. Thank you, Your Honor.
Okay, thank you. All right, as to the first-degree murder and the conspiracy to commit first-degree murder, there's enough to go to the jury, so I'll deny the motions for JOA as to those. State, what's your response to the attempted first-degree murder and the tampering?
Judge, to the 3 counts of first-degree attempted murder, we're not going to be relying on transferred intent. There is absolutely enough evidence to go before this jury for all 3 of the shooters in this case. It is very clear that there was a coordinated effort between those 2 vehicles with surveillance conducted on the victim and the victim's party at 2 separate locations before targeting the victim. And at both of those locations, they had Isaiah Chance and Alicia Andrews watching the victim. They were aware of who was in the victim's parties, how many cars were there. They were surveilled at 2 separate locations and then followed and tracked the last location. You saw the state's exhibits of the vehicle inside the interior of Charles Jones' black Dodge Charger. Each one of those headrests, the front passenger seat, the driver's seat headrest, both for the front, both had in it bullet hole damage. Those are kill shots. Everywhere where a person sat in Charles Jones' vehicle, in the front seat, as well as in the back seat, there were 3 passengers, and in the back seat, that headrest also had damage by bullet holes. That is evidence that all of those individuals in those cars were targeted. They were watched, and they were highly trained shooters that fired upon that car. All of the individuals in that car got shot, and the one vehicle that Camilla Bentley was in was another vehicle of the victim's party. They knew each one of the vehicles that were involved in this case, and there are 2 clear shots to the back rear windshield of where Camilla Bentley was driving away in that car, again indicating that they were very well trained and that they were directing their gunfire to the vehicles belonging to Charles Jones's party. And so that is evidence that they were intending to kill Charles Jones and the people who were traveling with him. And based on the evidence in this case, you can clearly see that those shooters were highly trained and very skillful. And based on that, we would ask you to deny the motions to the first-degree attempted murder on all 3 of the shooters.
All right, let's talk about the tampering.
As for the tampering with evidence, Judge, it is very clear that the defendant knew that an investigation would be instituted by law enforcement. They shot up a hotel with 2 AR rifles and a Switch extended magazine Glock at a hotel with cars that were full of cars. To think that law enforcement wouldn't respond and start an investigation is beyond imagination. Everybody knew that law enforcement would be investigating that based on those facts alone. But not only did they shoot up a hotel that were full of guests moving in their kids to the USF dormitory, they took out a prominent Jacksonville rapper. They absolutely knew that law enforcement would be starting an investigation into this. And knowing that that vehicle was used in a first-degree murder, he purposely hid it, and he tried to hide it, not in Jacksonville. He didn't drive it to Jacksonville. He tried to hide it in Polk County with his grandmother so he wouldn't be caught driving a vehicle that was just used in a homicide of a prominent Jacksonville member. And he is literally seen on video wiping down evidence, which could be fingerprints. That is destruction of evidence. There were 3 shooters in that very vehicle, and he is seen wiping down the very areas where the people getting in and out of that vehicle would be touching. And so that absolutely is not just the wiping down of the vehicle, it is removing that vehicle, which was an instrument of the shooters, which carried the shooters that killed Charles Jones, and removing it from Tampa and his attempt to hide it in another city that is not involved in this investigation. Both of those things that he did is sufficient to go to the jury for tampering with physical evidence.
All right, at this point in the proceedings, I'll deny the motion for JOA as to attempted first-degree murder and the tampering. See what the jury does. Okay, so you've got a witness, correct?
She's in the hallway.
Okay, and you guys ready to go? Okay, let's just take a quick 5 minutes and then we'll start with that. And at this point, at some point, we need to have the colloquy with the defendants about whether or not they're going to testify. So why don't we get the witness on and off the stand, and then we'll have that colloquy, okay? All right,